Lawyers of Reddit. What are your worst "this guy isn't winning" cases? So, friend who is a criminal defense attorney was called at 3-something a.m. by the preceding judge. Says to him, "The sheriff is on his way to arrest your client, who is having his bond revoked. I'm calling you at 3 a.m. about that because he is having his bond revoked for posting a real name social media threat directed at me and my family." Next story. I worked for a trial graphics firm and was working on a case where a forklift driver was driving maniacally and ran into a cinder block wall of a new construction. It caused enough damage that a gentleman on a ladder on the second floor of the structure fell and fractured some vertebrae. The forklift driver was reprimanded the day prior, driving the forklift in an unsafe manner. Then, in his deposition, he bragged about how many speeding tickets and traffic violations he racked up in his Corvette. It was fun watching the deposition back with the plaintiff's attorney. Next story. Client sued for injuries from a car accident. He had about 3 or 4 other accidents within the 3 years prior. One of them was a big rollover accident. He had medical treatment for all of them, but he only disclosed the accidents that were not the rollover. Also, insurance companies saw on his Instagram page that he went skiing even though he was complaining about pain in his lower back. That was so bad he couldn't walk, apparently. But man, we should have never taken the case. I don't know why the office signed him up. Next story. I saw a defendant pulled in for a show cause for violating probation. His drug test had showed positive for cocaine. He stood up and shouted that it was a false positive because he drank 3 2-liters of Coke that day, he said. His lawyer grabbed him to sit down with one hand while face-palming with the other. Next story. Jury trial. Client on the stand. We'd gone over this evidence dozens of times before. The date of the service of a document was dispositive for the entire case. Question. What is the office policy regarding issuing this letter to overdue accounts? Answer. Well, we do it on the 5th of every month. And I was already ready to facepalm here because the document is dated the 3rd. But then I say, Exhibit A is dated the 3rd. Why is that? Hoping she would say the 5th was on a Sunday, so we wanted to get it out early. But instead she said, I don't know. It shouldn't be. If the 5th is a Sunday, we're supposed to serve it on the 6th. Double facepalm. Then I say, but if you dated it the 3rd and signed the proof of service for the 3rd, that would mean you served it on the 3rd, right? Objection. Leading. Sustained. Absolutely the correct call by OC and the judge. Then I say, when did you serve the document? And she says, I have no idea. Next story. A man approached the court for a reduction in his child maintenance payments to my client while driving a brand new BMW SUV. He said because I was a junior at the time, he'd handle the case himself and he'd squash me. Then, after his poor attempt at compiling his disclosure of financials, he was investigated and it was found out that he was laundering money through a fake online church. He's now being criminally prosecuted. Next story. Not a lawyer, but I felt the need to share my own singular soft-sit experience. Canadian, by the way. In traffic court, waiting for my turn, a guy is called, stands up, and is dressed and looks respectable. Business suit, clean, hair combed, suitcase. Would have guessed he was a lawyer if he was sitting ahead of the bar. He stands up and says out loud, well, I have a driver's license with that name on it, but as it's in capitals, you can see that's the name of a corporation, Your Honor. The justice on the bench did his best to be reasonable with this guy, but the guy immediately starts a speech about how the system is corrupt and there needs to be changes. He would go on about that several times in the next while. This first time, the justice says, that's not what we are here to discuss today. We're here for a speeding ticket. And if its defendant's name doesn't present himself in front of this bar, I'm ruling a conviction in absence. So the defendant hustles in front of the bar, officially presenting himself for the case, behind the bar's gallery only, and then proceeds to start an indignant series of acid-born arguments that were so bizarre as to verge on schizophrenia. Some highlights were trying to invoke papal law, which the justice responds with, papal law? This isn't Rome, that doesn't apply here. Then the defendant tries to quote admiralty law, which perplexes the justice as, where do you get admiralty law? This is Alberta. This is the most landlocked province in the country. Where do you get admiralty law? The defendant replies, straight-faced and serious, well, there used to be a fountain in the basement, sir. And mind you, defendant hasn't even made his initial plea yet. Multiple times the justice tries to steer him back on track, and the guy keeps responding, well, I did it, but that's not the point. So, after a bailiff has been called to keep an eye on this thing, and I, witnessing this, have finally realized I wasn't dreaming, the justice on the bench finally says, okay, fine. You've said you've done it multiple times before, and I'll accept that as a guilty plea. Then hands out a fine and 30 days to pay. Next case. Next story. Potential client says to me, I want to sue the Hilton for racial discrimination. They refused to let me use the pool because I'm black. So then I say, you came down from your room and they told you no? Well, no, I came in from the beach and they said no. Wait, were you staying there? No, but there were white people in the pool and a white guy said I couldn't use it. And yeah, another lawyer took the case. Either didn't ask the right questions or just didn't care. Okay guys, so I've worked in customer service. I've worked in fast food. I do these voiceover videos and I will talk like this and people will still say, is this AI? And it's really occurred to me recently, some people are actually put on this planet to be stupid, to be NPCs, to make you feel better about yourself and to lower national averages. Some people actually exist to be stupid. I suspect maybe they did something in a past life and are paying for it now, or they're working their way up the ladder so that they could be a billionaire 5 lifetimes from now, but some people just, oh my God. Next story. So, not a lawyer, but a witness. Defendant stole the charity pot from a petrol station and caught the back of my car while driving out. Trial was postponed once due to medical reasons, and I'd moved houses, so I had to travel 3 hours from my new place because they wanted to use me to add driving charges to them. Well, the day of the trial, I went out to grab lunch from a supermarket around the corner and saw someone getting collared by a security guard for trying to steal. Went back and was eating my lunch when the prosecutor came in and let me know the trial was canceled as the defendant had been arrested. Yup, he attempted to steal from a shop while waiting for his trial for theft. In the end, he pled guilty to half the charges, and they dropped the driving ones so I didn't have to travel down again. Next story. Client was on trial for murder, 1, and OG's case looked like a plot from Suits compared to this. Nobody has ever been worse at crime in the history of crime. Now, we were appointed counsel, which means we're private employees who sort of offer to be on standby when they run out of public defenders. We were his 5th. He'd fired the 4 prior because they kept telling him to just get started on the life sentence because this was already over. And they were right. My client was on trial because he executed his girlfriend with a pair of gunshots. He did it because she'd secretly aborted a pregnancy that might have been his. He found out when he picked her up at the clinic. As they drove home, both of them live texted their hour of conversation, including all of threats to kill her for this when they got home, which he did. My client's apartment building had recently upgraded to full-color telescopic 4K security cameras. We think he didn't know the upgrade had closed the blind spots. Crap looked like the film from the Super Bowl. My client was also the only 6'4" Hispanic man with bright red hair and a taste for rare designer sneakers that I and his victim had ever met. This makes it difficult to argue it is not him while the prosecution places Gotham City highlight reel on a projector. My client not only shot her with his own gun, he brought his phone with him while he drove out to the remote spot where it was found. My client also texted his friend to buy him the next one-way ticket to a different country, no questions asked, and he made sure to give him his credit card to buy it though, because we can't leave our homies on the hook for that bill. Finally, my friend client had to hide his grin under his hand while the victim's family cried on the stand. The jury deliberated for 43 minutes. Next story. Happened to a friend of mine a few years back in Canada versus TELUS. TELUS offered a promotion on his contract and he would always call in and say he just wants his original contract price, which was $15 cheaper than what it was worth now. So every year he would call in and ask if he can extend his contract by another year. Well, last year, as that price was practically non-existent, they immediately bumped his price up when he phoned in, stating that he was on a glitched account and his original contract was newt, because they didn't sign a contract every time they extended it. So they charged him over $8,000 for the plan. But what TELUS didn't do, or this rep and this whole department didn't do, is that they should have asked to see the contract he had first, and seen that they did do that. And he has emails, phone calls, dates, and letters and pictures to prove that they did. So he takes TELUS to court, hires a fancy lawyer, and seeks, I think the maximum in BC small claims is $40,000. So $40,000 in mental anguish, breach of contract, and pressure tactics. And he wins. The lawyer warned TELUS and said, hey, I put a lot of evidence into discovery for you guys to comb over, and you guys sure you want to pursue this? It's a pretty strong case. I highly advise to look at this. And TELUS said, no need, we have our proof. And their proof? Well, original contract that has an end date, and their defense looked super smug and happy. My buddy's proof? All the amended contract emails, agent names, dates, phone call transcripts that they got from TELUS, everything. Judge ruled in my buddy's favor, and even made the comment, hey, he gave you a chance. Next story. Okay, it wasn't my client, but I was prosecuting a case. DWI, third offense, reckless driving, negligent use of a firearm. And not relevant, but the law on that one needs to change. If you're drunk and a cop found you with it in the car, that's enough to convict 99% of the time through our office, which would dismiss that charge for a DWI plea. But anyway, there was also assault on a police officer. In our jurisdiction, DWI fourth is a felony, so preliminary hearing required. Those are usually waived since it's pretty clear if PC existed in DWIs, but the defendant is pro se and refused to waive. So I finish my questioning of the officer. Defendant requests cross. First question, isn't it true you only added the assault charge because when I hit you, you started crying like a B-word? Effing stunned the entire courtroom. Judge told him to watch the language and recommended that he be represented by an attorney since the question was also an admission. Pretty sure he just wanted to do it for the spectacle. He said no further questions. Judge ruled PC existed to continue. He came over to me talking about pleas, and we wrapped that up before the end of the day. Next story. Not a lawyer, but a business acquaintance was being sued over a slip and fall that apparently left this guy permanently disabled and unable to walk. His scumbag, by reputation lawyer, turned down settlements and was apparently a nightmare in court-ordered mediation. The whole thing fell apart when my acquaintance's lawyer won a hearing over the plaintiff's motion to exclude video evidence from a private investigator. Well, guess who was recorded multiple times walking and once running in the rain into his lawyer's office? Apparently, the judge ruled in a morning hearing and the case was dismissed with prejudice before close of business that same day. Next story. Order of prosecution. Victim filed. Abuser shows up for court in a suit with sunglasses on. I don't have proof of this, but he was a meth addict, so pretty sure he was trying to hide the pinpoint pupils. But abuser decides he's going to exercise his right to hear what he has done and question the victim. Victim gets up on stand and answers his questions honestly. One of the questions was, "Why are you working with the police to put me under surveillance via cameras in my light fixtures?" Victim responded, "There are no cameras. You're on meth and hallucinating." Cue courtroom erupting in laughter, including the court employees. I've never seen a courtroom get so loud in real life and watched the judge start yelling for quiet and banging the gavel. Victim was terrified she had done something wrong and kept apologizing to the judge. At the end, the judge granted the longest OOP possible via the state, then excused the victim and the family. As the victim was walking out, the judge laid into the abuser and then some about how much of a disgrace he was to the community and how his parents and grandparents were rolling over in their grave. He should be ashamed of himself. The judge continued this until they determined the victim had time to get in their vehicle and leave. Next story. My dad was a corporate attorney who occasionally tried cases. His worst experience was representing a racist property manager. The plaintiff was a black nun who was so distressed by the situation that she lost large clumps of hair. My dad had to question her while she cried on the stand with the visible bald spots. He felt absolutely horrible, and his client lost. Next story. I'm not a lawyer, but my mother-in-law's divorce attorney would have a great answer to this. My father-in-law started to suffer from early onset dementia, which triggered a series of events resulting in my mother-in-law not wrongly filing for divorce. Throughout the 3 years of divorce proceedings, my father-in-law's condition became very obvious, to the point he was showing up to court proceedings in garbage bags when his lawyer was able to get him there. By the end of the divorce, he was living in a memory care facility, which was about as close to hell on earth as you'd imagine, and his sister had power of attorney. When everything was settled, their estate was split 50-50. Yet my mother-in-law insisted he was faking it and he had millions on offshore accounts. So she sued. She couldn't prove he ever had millions of dollars in the first place. She insisted he was faking it despite several doctors attesting to his condition. So pretty much all of the proceedings were she's not winning, but she insisted. When their divorce proceedings were finalized, she had over $750K, but by the time her failed attempt to sue ended, she was down to only $125. Okay, girl, what? You spent $600K trying to sue this man? You just got some bag. If you're old enough and smart enough, you could invest that. You could buy cookie dough for the rest of your life. I don't know. What a dumb... Some people are put here to be stupid. Some people are put here to be stupid. I am squeezing my stress ball. I don't have one. Do you hear that? Anyway, next story. So, I was the defendant, not the lawyer, but I'll make this quick. If you're going to try to sue for in excess of $100,000 for life-changing injuries over a tiny no-damage fender no-bender, maybe don't leave your social media public. And if you do, maybe don't upload pictures and video of yourself rock climbing, hiking, and going to extreme trampoline parks. But anyway, for the record, they got nothing. They should have settled with the insurer. They'd have gotten $10K to go away. Next story. This is rather boring compared to other stories. It was a child custody case in a county I don't normally practice in. Mom, my client, wouldn't agree to a rather good settlement agreement and wanted her way 100%. She wanted a judge to decide rather than the parties settling where they both walk away winning and losing in a sense. The hearing starts, the judge enters, we all rise like you typically do, and the judge unleashes a tirade telling us to sit down. It's obvious we're from the big city all dressed up, but it's his courtroom and he's in charge. Then the judge mentioned his military service, and I knew that minute we weren't going to win the case, because the dad was former military. I pissed the judge off by not taking the time to know how he operates his courtroom before appearing in it. Judge ordered dad a favorable opinion. Mom was mad. And I learned two valuable lessons. The first is that settlement is preferred because you at least have some control over the outcome. And the second is get to know the court that you are in. Edit. Most civil court cases are legally nearly 50-50. Both parties have legal standing to present their version of events and proposed remedies based on legally sound arguments. There's only an idiot hair of legal difference between the two sides. Having a professional relationship with the judge and county bar association can be the difference between winning and losing a case. If there's not much to go on, the judge is going to side with the one person they know because it becomes about character and trusting a lawyer's candor at that point. It's just a reality. Next story. Client's in jail awaiting trial for an unrelated charge. Client decides he wants out of there and stacks chairs in the rec room. Client climbs chairs, pushes through the ceiling tile, then crawls on top of ceiling towards the next room over. Client falls through the ceiling 5 feet from the starting point and plummets 10 feet in a shower of ceiling tiles. Client then somehow manages to land on his feet, then grabs fallen ceiling tiles, stacks them on top of chair stack, then attempts to escape again. Client falls through a different part of the ceiling, and all of this is captured on jail video camera. Next story. I'm not a lawyer, but I've seen several clips of the trial of Daryl Brooks. He drove his car through the Waukesha Christmas Parade in 2021, killing 6 and injuring over 60. Throughout the entire trial in which he represented himself, he did nothing but dig his own grave while irritating everyone else in the courtroom. The judge absolutely threw the book at him, ultimately imposing 6 life sentences and an additional 1,000-ish years with no chance for parole. Next story. Not a lawyer, but I used to sell advertising to attorney. I was walking into an attorney meeting when he pulled me aside and said, "We need to reschedule as he's in a bit of a complication right now." I asked him what was going on, and he said, "Well, my client brought his girlfriend to his divorce meeting with his wife." And I went, "All right, you have fun with that," and I wished him well and left. Next story. Not a lawyer, but this one always makes me chuckle. A friend of mine rear-ended another vehicle. They exchanged info. There didn't seem to be any damage or injury, and they went on their way. 2 years later, though, my friend receives word that she's being sued for injuries from the accident. The other party had a sprained wrist and was suing for $25,000 for pain, suffering, loss of wages, etc. So my friend calls her insurance company and they say they'll take care of it. Long story shorter, insurance company offers her $5,000 for her to go away. She insists that her injuries deserve better compensation. Then they offer her $7,500. She still refuses. They offer her $1,250, and she laughs and then says, "See you in court," and they did about a year later. Case went before a jury, and she won and was awarded $2,300, 1/3 of which had to go to the lawyer that she had hired. So instead of taking $12,500, of which she would have gotten 100%, she went to trial and ended up getting 66% of $2,300, so about $1,500, and had to wait a whole other year to get it. Yeah, that's a win. Next story. So I'm a public defender, and where do I start? Had a resisting an officer case that was actually a good trial case. Unfortunately, there were certain facts we needed that could only come in through my client, so it was the very rare instance where the client needed to testify. And during cross-examination, he randomly blurted out at the jury, the entirely rural, white jury of conservative blue-collar paper mill workers, "I thought I was going to get George Floyded." Read a room he could not. Then had a client pulled over for driving at nighttime with his headlights on. Officer gave him a warning and then let him go. And then in passing, while turning to go back to his squad car, asked, "Oh, you don't have anything illegal in your car, right?" His response, "Nah, you can search it if you want to." And pro tip, if you give the cops permission to search your car, they're gonna search your car. Shocker! Found open containers, 0.27 blood alcohol concentration. I have so many stories. Next story. I was defending the case, so it wasn't my client, but the guy testified very clearly, under oath, multiple times, in no way that could be mistaken that he was seen by a very reputable specialist who diagnosed him with an irreversible condition. That was a key issue in the case. Well, we ended up settling for nothing more than nuisance value, nearly pocket change, but I was holding in my pocket until trial, in case I needed it, that the reputable doctor had died several months before he evaluated this guy. That would have been a fun one to try. Next story. I'm not an attorney, but I work for the state equivalent of the IRS. My job is to resolve tax disputes before trial, and if they go to trial, I am the state's primary witness. This means I'm subject to cross-examination by the other side, typically the taxpayer. I was dealing with a difficult, agitated, aggressive taxpayer for an extended period of time. This is common before trial, and we try not to go to trial, so there was a prolonged period of me trying to explain why we did what we did. I had some brutal trial prep with our attorneys to get me ready for anticipated cross-examination. And to reiterate, I work for the state equivalent of the IRS. The IRS being a federal agency. So anyway, I gave my testimony, then the taxpayer was allowed to cross-examine me. And he asked me why the IRS disallowed his refund. And I explained, for about the fifth time, I do not work for the IRS, and I do not know why the IRS did what they did. He would need to ask the IRS. I was tempted to comment that if the IRS also disallowed his refund, it would appear the state-side adjustment was also correct, since we follow federal law, but I decided against it. Then next he said, no further questions. And going to trial is expensive, by the way. Both sides had to split the costs for the court stenographer, $1,400, so $700 each. And during the lead up to the trial, I told him multiple times we are not the IRS. Dude literally paid $700 to ask me under oath if I worked for the Internal Revenue Service, because apparently me telling him multiple times that I don't, and all of our correspondences being on my state's letterhead, was not good enough for him. I think he may have had some brutal follow-up questions for the IRS, and he was completely blindsided by this revelation? I don't know. The amount at issue was about $3,000, so $700 was a hefty amount for the taxpayer. And, of course, he lost. We knew we were probably going to win before trial, but when he declined to even ask me any questions which could advance his case, it was clearly over. Next story. My squad was searching a stash house on a warrant. This was part of a takedown of a violent organization, and there were a bunch of houses being searched at the same time. The house I was in was a known stash for guns and drugs, and during our investigation, one of our UCs bought multiple guns which came out of this house. Well, I was searching the kitchen in full kit when someone opened the back door and popped their head in. I turned around, he looked at me, I looked at him, then he backed out and slammed the door shut. I ran to the door, opened it, and he was standing right there with his hands up. I sat him down on the patio steps and started to get his information while my sergeant ran him through NCIC. The guy was cooperative but wide-eyed and nervous as hell. As I stood there and began to look at his waistline, I could see a clear outline of a gun in his jacket pocket. My BWC footage showed what was almost textbook printing of the gun while I stood in front of him. He didn't fight, he just accepted getting cuffed and arrested, possession of a handgun by a prohibited person. He went to booking, and after getting into the jail, he made a phone call. Keep in mind that the phone system very clearly says all conversations are monitored and recorded. During this phone call, he told the other party that he had a satchel with $700 cash and coke that he tossed over the fence before I came out the back door. Well, a couple of detectives went over there and they found the bag. There was a big snowfall that morning. There were no footsteps anywhere near the bag. The bag did not have any snow on top of it. And inside the bag was $700 cash, cocaine, and the guy's driver's license. Dude filed a motion to suppress. His position was that I had no right to detain him. He lost that motion pretty badly and pled out. Then our state's attorney cited something like 7 clearly established cases which showed that this position was comically wrong at best. At the end of the hearing, the judge told the guy he was going to put him in an employment education program because he needed to find a new job because he was so terrible at being a drug dealer. Next story. Not a lawyer, but work in the courthouse. Had a civil trial with judge and jury, which is super rare for us because who the F wants the unpredictability of a jury in a motor vehicle collision? Now, there was a car accident. He sustained injuries to his back, his spine, his neck, his head, his tailbone, and about 3 other ways of describing back pain. He hadn't initiated the action until a year later because a lot of his symptoms were late onset. Then, on the stand while testifying, he admitted something to the effect of, "I wasn't going to bother with suing, but the cost of living crisis has gotten out of hand. I'd like to buy a house and real estate prices are crazy high, so I'd like the money. And surprise, surprise, this did not sway the jury, who had to give up 2 weeks of their lives for this guy's stupid trial. He lost. So on top of his financial worries, he was on the hook for the other guy's legal fees. Next story. I've had quite a few doing Social Security disability. Typically speaking, it's people who have gone back to work and didn't tell me, or that all of a sudden remember they actually volunteer 40 hours a week once they're under oath. But the most memorable one was the guy who was being questioned by the judge about his marijuana usage, which was noted in his records. And after being asked if he used any other drugs, starts listing off meth, heroin, coke, etc. Pretty much you name it, he had done it. And then informed us all that he had last used about a month prior. And that was a denial I didn't appeal. And a real interesting call with his mom when she called me super pissed about him getting denied and me recommending not to appeal it. The judge had actually done him a solid and completely left out all of the hardcore drug use in the decision, so it wouldn't be an issue for him in the future if he got clean and tried again. But that made his mom think that the judge had clearly denied him based on bullcrap, as he had only mentioned the alcohol and the weed. Next story. Not a lawyer, but I was in a 5-mile-per-hour car accident. Bumper-to-bumper traffic, rush hour, everyone just inching up every 39 seconds or so. The genius next to me pulled into my lane. His passenger rear tire made contact with my driver's side front tire. Pulled into a fast food place to wait for the police because he insisted on a police report. 1 week later, I get the news that he says I pulled into his lane and he has a litany of injuries, and I was absolutely livid. He was lying and trying to game the system. And I went on a mission to learn everything I could about him and discovered that he had fancied himself a personal trainer. Amazingly, he was holding a group session at a public park the very next weekend. Now, I live in Florida, which does not allow recording without consent unless you're in a public space, so I set up a park bench that same weekend and recorded his dumbass for 1.5 hours. Pull-ups, push-ups, ropes, throwing a giant medicine ball. Dude was definitely in shape. And I sent the video to my insurance company and told them not to pay a dime. And they told him to pound sand, and we all lived happily ever after. Next story. DUI, third offense, single vehicle crash into a guardrail at about 15 miles per hour. Driver was arrested and booked in a shirt that read, "No laws when you're drinking claws." There were 5 empty White Claws in the passenger footwell and a cold, half-empty White Claw in the cup holder. The first and second offenses were both less than 5 years old. I requested a Scram device, which is a portable breathalyzer, to read 4 times a day without making much of an argument. Defense counsel raised a stink about the intrusiveness of the monitoring device. The judge just looked at him, then at the defendant on the dock and said, "Nice shirt, sir," and he got put on the Scram. He pled out, which was a shame though. My opening was just going to be waving his booking photo at the jury and intoning, "Turns out there are laws even when you're drinking White Claws." Next story. Late to the party, but I am a lawyer who ended up on jury duty. Gotta love when both sides use up all their strikes before they get you during voir dire, and I sat on a criminal case. It was a late night, early morning purse snatching. Guy stole the purse from women just as cop was driving by, and there was a line of sight on the defendant for all but 30 seconds, and there was also blood evidence from where he cut his hand while jumping a fence, leading to a 99.9% certainty. The defense's full argument was that the person who stole the purse was wearing a shirt, and his client, when arrested, was shirtless. Keep in mind, there was a shirt found along the direct path of pursuit. But anyway, I get that you've got to hang your hat on whatever you can to defend your clients, so I respect the effort. That being said, when the prosecution entered into evidence a statement of the defendant asking the police, "Hey, can I have my shirt back?" you could hear the face palms from miles away. So glad I practiced transactional law. Next story. I did a lot of child welfare back in the day. Had multiple parents who were trying to get their kids back walk into court with wildly inappropriate outfits, t-shirts with pot leaves, back when people cared, sexually suggestive graphics and slogans, a hat that said "Cop Killer." Didn't really impact the outcome, but sure as hell didn't help them that day either. Then had another guy who was a pretty decent dude, but chronically homeless. He came in with a ragged suit and tie and apologized because it was something he found in a trash bin, but said he wanted to look the best he could for court. Got custody of his kid, and the state wrote all kinds of checks to help him get back on his feet. So long story short, giving a crap that you are in a courtroom in the first place goes a huge way. Next story. Of federal criminal cases, 91% end in conviction, and 8% are dismissed before getting significantly underway. Most of the time, this guy ain't winning is the default. Occasionally, overreach of the prosecution happens, but it's rare. They don't want to waste their time or make themselves look bad. When they go to court, typically it's because they know that they'll win. So almost everybody isn't winning. Next story. Gal is charged with violation of a restraining order. She was ordered not to come within 100 yards of her ex-boyfriend's house. He calls the cops, says that crazy B-word is here again. Cops pull up and she's in the front yard waving her arms and screaming nonsense. They walk right up and cuff her. I try to get her found unfit to stand trial, but it doesn't work, so she demands a jury. I'm standing there in front of the jury contemplating trying the Shaggy defense in real life. What else did I have? Next story. Not a lawyer, but my ex-wife drew out custody hearings for several years, all in a bid to keep me paying for her standard of living. Her main tactic was character assassination, and after several years of that, it wasn't working terribly well because, well, all of the officials involved could plainly see that I was nothing like the person she described to them. So once they made it clear that they didn't believe her story that I was abusive, violent, negligent, or likely a predator based on readily observed evidence from several years of hearings, she tried to convey that I was financially unreliable. Again, she was trying to get money out of me and sole custody of our daughter. Hold on to your butts, though, because it gets dumber. I was enlisted in the Air Force at the time, and she told the judge that she expected me to get discharged in the near future because of list of debunked accusations, and the judge asked me if this was true, and I answered honestly that the only time it was even suggested that I might face a discharge was when we were still married, when she called my first sergeant and commander daily trying to get me discharged. Once we were divorced and they no longer had to answer her calls, it never came up again. In fact, I was the highest-ranking, second most awarded, and most knowledgeable person in the unit. The judge asked her if what I said was true, and the ex said it was, that she'd actively tried to get me discharged. In my head, I'm screaming that she tried to get me discharged so that she could justify cutting me out of our daughter's life entirely. But I glance over at my lawyer and see that he suddenly looks very interested in what's happening, so I sit quietly, and the judge asks her again, in a very careful tone, "So, you admit that you actively tried to get the sole source of income for you and your daughter essentially fired from the job that provides said income?" And she said yes. The judge asked why, and she said, "Because I don't think he's a good fit in that job." And anyway, my lawyer put down his notes and smiled. Next story. Not my client, but it was my case to defend. There's a type of suit known as a 1983 that plaintiffs file to allege that their constitutional rights have been violated. Well, guess which constitutional rights this genius claimed were violated? Those rights pursuant to the 13th Amendment of the Constitution. You know, the one that prohibits slavery. And you're probably thinking this guy is a fool and he has no idea about constitutional law. And yes, but the plaintiff was an attorney and he was claiming that certain conditions of his employment violated his constitutional right not to be a slave. These horrible conditions were to come to work and do work as assigned by his boss. Suffice it to say, the judge was not impressed, granted the motion to dismiss, and yes, sanctioned the plaintiff for filing a frivolous lawsuit. Next story. Not a lawyer, but served on jury a few months ago. Members of the jury were instructed not to discuss details of the case with each other, but we were sent out into town to fend for ourselves at lunchtime. On the first day of the trial, I and all the other jury members could not help but notice a half-dozen instances of the thing the plaintiff's expert witness testified about, and the expert witness testimony was very wrong. Plaintiff lists the trial right then and there. During deliberation, which lasted maybe 2 minutes, the entire jury referenced walking to lunch on day one as clinching the no liability decision. The plaintiff lost because the jury had a chance to inspect sidewalks. Next story. I once had an evidentiary hearing where the opposing counsel had just misread the law. Not a big deal. However, the law was relying on a statutory defense that only applies to cases that had gone to final judgment beyond 30+ days. Both my brief and memorandum of law in support of my client's position made clear reference to the rule and why opposing counsel's case was fatally defective. When the case was called, and I'll never forget this, the judge didn't even allow opposing counsel to begin his argument. It was just, "Counsel, your motion is denied. Call the next case." Next story. My wife gets those coming both ways all of the time. She is a labor and employment attorney. She works exclusively for the business side and never the employee side. She'll review the cases and straight up tell her client that they don't have a foot to stand on, and she's going to be doing damage control and that they need to be ready to write a check. On the other hand, she'll get a phone call from opposing counsel and they know their client doesn't have a case and they'll shoot straight. Opposing counsel will be like, "Yeah, this guy thinks he's going to get $5 million from your client. He's an effing clown. What's the highest you're willing to settle this for?" Next story. I'm not a lawyer, but had a law class that was taught by a lawyer who told us this story and had us do a project over this active case he was a part of. Not civil, though. He wasn't committing any crimes by having us do this. So basically, this guy decided he wanted to see his kid on his kid's birthday and went over to his wife's house. They were living separately. The kid said he wanted to go with his dad, but his mom wouldn't let him do this. Dude forcibly grabbed the kid and tried to leave. Well, his wife then attacked him, and he ended up grabbing a hammer and getting her with it a couple of times. Well, when it's time for court, this guy decides he doesn't want a lawyer and would rather defend himself due to the fact that he had done that before and won, somehow. And in his pre-trial hearing, no, not even in trial, the dude tries to get out of this by claiming that his name isn't actually what is on the judge's sheet because he claims he writes his name in all capital letters, which makes it an LLC. Obviously, the judge doesn't care because that isn't how it works, but the dude keeps claiming that he doesn't recognize the charges against him and claims his LLC is actually being sued, not individually charged with a crime. So the judge decides to revoke his right to represent himself. Due to this, she claimed he wasn't competent to represent himself because he refused to acknowledge that he wasn't being charged as an LLC, and the guy is given a lawyer. Well, he loses the case and gets really pissed off because he thinks he could have won it if he defended himself and decides to appeal, and claims the judge took away his civil rights. However, in his appeal, he just conveniently decides not to send the transcript of the competency hearing that the judge used to decide if he was competent to represent himself or not. Again, in this appeal, he is given a lawyer and not allowed to represent himself, who is my teacher this time, and then tries to sue my teacher because he doesn't want a lawyer that badly. My teacher got unassigned from this case after telling the judge, but the guy didn't win the appeal. Next story. So I'm not the lawyer, but my late grandpa was. He had this absolutely legendary story about being a defense lawyer and having a client who did an armed robbery. My grandpa says to the judge, who he knew quite well, that he felt like his client, Mr. Armed Robber over there, deserved to be tried by a jury of his peers. The judge then says back to my grandpa, "Really? Where am I supposed to find 12 more armed robbery suspects who can come here at 7 o'clock in the morning?" Well, folks, that does it for another law-themed video. I'm going to be honest, whenever we read these videos, sometimes I just don't know what they're saying. Having narrated and done these videos for like 2 years now, I've found that military, medical, and legal stories don't always translate well. Mainly because the person writing the comment doesn't make it in layman's terms or use accessible language or explain what these abbreviations are. This video wasn't too bad though, but every now and then I was just like, yeah, sure, whatever. But anyway, guys, thank you all so much for watching, commenting. Have a really good day, and bye-bye!